Okay, well, hello everybody and welcome to today's live search discovery education community. My name is Julia Petrie and I will be your host today. Before we introduce our speakers today, I'd like to remind you to please place any questions that you have for our speakers in the Q&A chat, and we will make sure to get to those at the end of today's session. I'd also like to encourage you to join our LinkedIn group. There you'll be able to connect with members of the search discovery education community. So to kick things off, as experts in the field of law, our speakers from Willkie, Farr, and Gallagher, LLP, they provide a unique point of view on how to prepare for privacy changes in 2023. So I'll kick it over to you, Laura, to start things off.
Thanks, Julia. Hi, everybody. I'm Laura Jill. I'm the co-chair of the Cybersecurity and Privacy Practice at Willkie in DC. I'm with my colleague, Nick Channon, who's also here at Willkie DC. And I think we will be joined maybe in progress by our other colleague, Daniel Alvarez, who is, I think got called away to some urgent issue, but we're hoping he'll join us. And if not, we'll cover what he was going to cover anyway. As Julia said, we're here to talk about the new U.S. state privacy laws that are taking effect in 2023, and a couple of them take effect January 1st, 2023. So not a lot of time to prepare if you haven't. And basically, we're just going to run through the background of how we got there, where we are in privacy law in the US right now. It's an interesting time. The timeline for these new laws, key terms that you should understand when thinking about, how to understand the laws and how to comply with them if you are subject to them. What they have in common, and then the unique features, because it would be too simple if they all said the same thing. That would be a federal law, and we don't have one of those. And then some tips on what you ought to be doing now and looking ahead, what you can expect and what we can all expect in developments in privacy law in the US. So the US hasn't really had what you think of as sort of a comprehensive, real privacy-focused law ever. It's all been very piecemeal. It's historically been regulated, privacy has historically been regulated to the extent that it's regulated at all, by sector or by demographics. So if you think of, a lot of people know HIPAA, particularly after the last couple of years with COVID, they know that HIPAA is the law that regulates certain aspects of health-related information. There's GLBA, which is financial services information, and there's a law called COPPA, which is the children's privacy law. But there hasn't really been a general consumer, comprehensive law dealing with consumer privacy and other aspects of life and business. So in 2016, a couple of years ago, the European Union passed the General Data Protection Regulation, which is the first really big, comprehensive, and at the time quite sort of groundbreaking privacy law. And that was incredibly influential in the way businesses fought it pretty hard, but it was incredibly influential in the way businesses started to think about privacy and the way others, advocates for privacy, particularly in the US and around the world, started to think about privacy. And in 2018, California passed the California Consumer Privacy Act, which is known as CCPA. We will see that there's a whole bunch of acronyms that look all very much alike, but CCPA is the first California privacy law that was passed in 2018. It has some aspects of similarity to GDPR. It has a lot of its own original content, some of which is helpful, some of which maybe is not. But that was passed, and then momentum really started to build. And so in 2020, there was a lot of momentum building behind state level privacy laws. California came back and updated CCPA, partly because it was a little wacky in places and didn't really make sense and had gone together in sort of an unorthodox way. And they made some changes to it to make sure to be more explicit about what it covered in some areas, to expand its coverage in some areas, to clean up some definitions. And also to create a new agency, an entirely separate agency in California to regulate privacy and enforce privacy, which is the CPPA, which we won't talk much about, but it's out there. Not to be outdone, Virginia, Colorado, Utah, and Connecticut all also passed state level privacy laws in the last 2 years. And all of those laws are now set to take effect sometime in 2023. California and Virginia will be January 1st. Colorado, keep me honest here. There, we have a slide for this. That's good because I have to remember. Colorado and Connecticut are July 1st, and Utah, for whatever reason, didn't want to wait for January 1st, 2024, so they're sneaking it in on December 31st, 2023. But all those laws are coming into effect. So what do you need to know? First of all, what are they talking about? What data is regulated? These laws are all focused on what's broadly referred to sometimes as personal information. Some of the laws, however, borrow the term that's used in the GDPR, the EU law, and call it personal data. So even just thinking about if you're drafting a privacy policy or making reference to what you're protecting, you have two different terms to deal with. But they both are defined largely, again, to mean essentially the same thing. And this is a mouthful, but I'll read it. Information that identifies, relates to, describes, is reasonably capable of being associated with, which is a little vague, or could reasonably be linked directly or indirectly with a particular consumer or household. So that, if you think about that, that gets pretty broad. It includes, but is not limited to, the following: if it identifies, relates to, describes, or is reasonably capable of being associated with, or reasonably linked directly or indirectly with a particular consumer or household. And then it lists some aspects, some key elements of data. And it's much broader. That looks broad when you look at it. It's broader than it's typically understood. We've normally thought in the US, based on essentially some data breach laws and the way we thought about privacy for years, it's things like social security numbers, financial information, driver's license numbers. It's really much broader than that. It also includes information about a person if there's a way to figure out with reasonable diligence without being, really difficult, who that information refers to. So it includes things like biometrics, like photographs of your face or your fingerprint. It includes things like preferences and inferences that a business draws from you, draws about you. And that's very common, as many people know, in the digital advertising industry, figuring out who do we think this person is, what would they like, what ads would they be interested in, and drawing those inferences. That's included in this definition of personal information. Things like, what page views do you make? So it gets pretty broad pretty fast. And then when you throw in that it could be linked or associated not just with an individual consumer, but with a household, you can see that it gets, quite broad quite quickly. There are some exceptions to what's considered personal information or personal data. Anything that's de-identified data, aggregate data that's about large groups of people but not specific individuals within that group, publicly available data. So if your name and address, I don't even know if they still make phone books, but if your name and address are in the phone book, that's publicly available. If your email is widely published, associated with you on your business website or somewhere else, that's publicly available. And the other exception from this is data that's protected by some of those other laws that we talked about briefly, like HIPAA and GLBA, that protect health information or financial information. That's carved out as an exception in these laws, so they're not essentially double regulated. Some other key terms. These laws all talk, again, with the exception of California, who enjoys being different, they talk about controllers and processors of data. In California, the controller is known as a business, even though in theory they're all businesses, and the processor is known as a service provider, which actually might be more sort of intuitive to Americans to understand. But a business or a controller is the entity that determines the purposes and means of the processing. Why are you collecting this data, and why are you doing whatever you're doing with it? If you're making those decisions, even if you're directing someone else to actually do the collection or do the processing, you're the controller. You're the one that has a relationship with the consumer, and you have more statutory compliance obligations. A processor or a service provider in California is essentially performing a service. They're processing that data on behalf of the controller. They have a contract, presumably, where the controller says, this is what functions we want you to do with this data. We want you to draw inferences for us with an AI engine. We want you to hold it and store it, for data security for us. Whatever those kinds of requests are, those are made by the controller, and the processor just does what the controller tells it to do. If the processor does anything else with it, if it says, oh, great, we have this data, we'd like to run our own analytics on it, they take themselves out of the processor category pretty quickly and become a business on their own. The terms of controller and processor both come from the EU GDPR. They're both new to US law, but I think they're going to hear more and more of them, and it'll be important if you are processing personal data or personal information to figure out whether you are doing so as a controller or a processor. And with that, I will hand it over to Nick to talk some more about applicability and other details of the laws.
Great. So, we've talked about controllers and processors and kind of the roles that different companies play. And we've talked about the fact that, collecting and processing personal data is what really kind of subjects you to the scope of these laws. But a really important kind of related point is just to whom do these laws apply, because they don't apply to everybody, and at least not equally. So kind of to level set and to begin with, an important concept to remember is that the applicability of these laws is based on the residence of the data subject, not the location of the business. So what this means is, for instance, if you're a company located in, Cleveland, Ohio, and all of your operations are in Cleveland, Ohio, your data center's in Cleveland, Ohio, all of your employees are in Ohio, but during the course of your business, you have, customers in Virginia, or you collect, personal information from people in Colorado, you could be subject to the laws in Virginia or Colorado. Again, it's the residence of the data subject, the person whose data you're collecting, that applies these laws to you. That said, there is kind of an understanding with these state legislatures that they didn't want to just, scoop everybody up. They didn't want to, have these relatively onerous obligations apply to small businesses or to businesses that aren't doing a lot with personal data. So, a theme that we're going to have for the next few slides is the idea that, the specifics vary state to state, but some of the broad ideas are generally similar. So some of the generally similar ideas between these states, some states apply a revenue threshold, where if your business is pulling in a certain amount per year, typically $25 million per year, anything over that is subject to the laws. Anything under that might get away from the scope of the CCPA. More common is to base applicability on a threshold number of data subjects, typically 100,000 residents of a particular state. So you need to have a really good sense of how much personal data you're collecting. Are you, is your company in the 75,000 person range, or are you starting to creep up to 100,000 people? And you need to have a really good sense of where those people are. And then finally, another threshold, and typically this goes hand in hand with the pure number of data subjects. So this is kind of an either or threshold, is if your company's generating a certain amount of revenue per year, typically 50%, from the sale of personal data, or selling a certain amount of personal data, typically the personal data of 25,000 people. So all this goes to say, again, you need to have a very, very, almost minute sense of, how much personal data you're collecting, where you're collecting it from, and what you're doing with it, to understand whether or not these laws apply to you. But so if these laws apply to you, what are the requirements? What are the things that these laws ask you to do? What do you need? What boxes do you need to be checking, to make sure you're in compliance with these various laws? So again, these are going to vary, state to state, in their specifics. But a typical requirement is that you disclose in a transparent, easy to digest, easy to understand manner what kind of data you're collecting, who you're collecting it from, what you're doing with it, why you're collecting that data, whether you're transferring that data to any third parties, whether it's, whether you're selling that data. You need to, on your website, typically on your homepage, post a easily accessible link that lays out your privacy policy. Now, where this gets a little complicated and where these laws are really kind of going to start introducing a level of frustration is that they all have kind of their magic words. They all want you to describe the same thing, but they expect you to do it in slightly different ways. California wants businesses to describe the personal data they're collecting using the categories of personal data that California has in their law. Colorado doesn't require that. Some of the laws require you to include, more information about your organization than other laws do. So you need to really closely parse those requirements to make sure you're checking every box. And the reason, this is the first thing that we put out, and the reason this is, kind of the first requirement we're talking about, is because this is how you you're putting your best foot forward. This is the most public aspect of your company's privacy program. So you need to make sure that, if nothing else, the public privacy policy you have is really, really buttoned up. But one thing that you have to include in this privacy policy, and that will flow from this privacy policy, are a set of consumer rights. So all of these laws have introduced for the first time in the US a set of rights that consumers have over the data that you've collected from them or that you hold about them. So, you need to, in your privacy policy, explain to consumers that they have these rights. And on the back end, you need to make sure that you have processes in place that allow you as a controller, or in some cases even as a processor, to help consumers exercise these rights. So the typical rights are the right to know, the right to be informed about what data you have, which is not just the privacy policy, but in some cases includes affirmatively telling data subjects what data you've collected from them, or even giving them copies of that data. Typically, states require you to provide the right to opt out of the sale of personal data or the use of personal data for targeted ads. Consumers typically have the right to correct any data that you hold about them if they find that it's incorrect, or to ask you to delete the personal data that you've collected from them. And then finally, going hand in hand with this, is you're not allowed to treat people, data subjects, differently because they've exercised those rights. So you can't, offer, you can't, charge more because people don't want you to use their data for targeted ads, things like that. Another common theme that we see with these laws, and that ties into these consumer rights, is the idea of limiting targeted advertising and data sales. We really see this as one of the key focuses of the state legislatures. Amongst myriad things that businesses in the world are doing with personal data right now, for some reason, these two things really have attracted the ire of a lot of legislators. Providing ways for consumers to limit the use of their data for targeted advertising and sales is a key concept with a lot of these laws. And you see it in the consumer right to opt out. And one thing that we really want to highlight here and to emphasize is that these terms, targeted advertising and sale of personal data, are not necessarily self-evident. And again, California is the special child in the room. They're with their definition of sale. So they define sale not just as, as one company transferring personal data to another in exchange for money, but also in exchange for any other valuable consideration. So if your company is transferring personal data to another company and deriving value from that, and then you might be selling personal data under the California laws with the attendant obligations that come along with that. And then another unfortunately vague and rather broad requirement from these laws that we see is an affirmative obligation to protect the personal data that you've collected. Typically, they require any kind of security recommendation or security provisions you have in place to be tailored to the particular data you have and the risk inherent with that data. So more sensitive data requires more stringent protections than less sensitive data. But ultimately, these laws don't provide a lot of guidance. So it's an area where you really need to look to industry standards, to anything that might have been published. The NIST standards published by the government are a really good area. You need to be able to document your security practices so that in the chance that you have a security breach, you can reach back out to these state regulators and explain to them why your security was reasonable and tailored to the data that you have. This final kind of common ground that we want to talk about is a newer one that these state laws have introduced, and it's one that won't apply to everybody, but is one that I think a lot of people need to kind of understand because it is new in the U.S. These laws have introduced the idea of sensitive data as a separate kind of special category of personal data. So you can see some of the categories of what constitutes sensitive data on the screen, but they're anything that would be particularly important to individuals, sexual orientation, health data, physical and mental health data, religious beliefs, but also genetic or biometric data. Laura mentioned in the definition of personal data that biometric data can include, not just fingerprints, but face prints, thumbprints, even facial recognition technology sometimes trips up the biometric data. And then also data that's collected from children, typically defined as anybody under the age of 16. And most of these laws require you to collect informed affirmative consent from data subjects before you collect that data. So what informed affirmative consent means is not implied consent. You can't just say, by using our website, you've consented to the collection of your biometric data. That's not going to fly anymore. People need to provide either a written or some sort of, they need to check a box. They need to do something that lets you know that they're okay with you collecting that data. And it has to be informed. You have to provide enough information about what data you're collecting and why you're using it for that consent to be considered, valid and real. And then kind of the last bit of the consent idea is that consent has to be freely given, which means it has to be able to be withdrawn. So you have to provide a way for people, if you're collecting their sensitive data, to say, down the line, I was okay with this, but I'm not anymore. So it introduces a lot of work on the back end for companies before you're okay to collect and use this data. And with that, I'm going to hand it over to Daniel to talk about some of the less common features in these laws.
Thanks, Nick. Yeah, so Nick has just gone over some of the commonalities. I think it's important to highlight some of the differences. Some of the differences are going to be sort of on the front end, compliance type issues, and frankly, opportunities that that might be presented to sort of figure out how to navigate this issue. Some of the differences, are going to be on the back end, and we see that right up front with California. Right, California has this very explicit requirement about a do not sell and do not share button. The do not share button is a new requirement under CPRA that will come into effect on January 1. The do not sell button is one that has been in effect in CCPA since 2020. So that's something that as a matter of sort of compliance, if you are engaged in an activity that meets the definition of sale, as Nick and Laura were talking about, you need to have that do not sell button on your website. That's the front end. Back end, California is unique among the states that have adopted a comprehensive privacy law in that it has part of the enforcement mechanism is this private right of action. And it's private right of action that applies in the case of security breaches where certain data was compromised and the plaintiffs or the consumers who were affected can show that the company that was breached did not take reasonable security measures. So that is this private right of action. The rest of the statute is going to be enforced and the regulations are going to be enforced. Well, today they're enforced by the AG. After January 1, I believe they're enforced by California Privacy Protection Agency that Laura mentioned that CPRA created. So that's going to be very different. Other states like Virginia, Connecticut, Colorado, you're primarily looking at the AG as the enforcer. Although what we've seen in California and under the CCPA is that plaintiffs' lawyers have been very creative about trying to use sort of general consumer protection laws as a means of getting in court, and then sort of grafting on CCPA requirements and saying, well, this is another statute, but it has become sort of part of the consumer protection law. Kind of creative theories like that. We may see some of those in the other states as well, until some court decides to shoot them all down. But for as far as the primary mechanism of enforcement, it's going to be your state attorney general's office and the folks out of that part of the government. Colorado has this very explicit mention of the universal opt-out mechanism, which is still in development. We'll have to see how that comes to fruition. Colorado AG is in the middle of a rulemaking proceeding to try to figure all of that out. Again, though, what's happening in California is that's the AG there in a recent enforcement action against Sephora is trying to bring this universal opt-out concept into CCPA. So you're going to start to see some bleeding over when states kind of come to realize that they like this thing that's in this other state, but it's not in their thing. How do they figure out a way to graft it on? So there's going to be some of that, but in the statute itself, there are these differences that we need to monitor. Colorado, Connecticut, and Virginia all require data protection assessments in various and sundry situations. And before conducting any processing that poses a risk of harm to the individuals. Here's a question.
We can answer that.
Okay. All right. So, those states require those data protection assessments. Other states will not. Companies will have to figure out how you address that. Do you do a state-by-state analysis? Do you do just a whole country, national analysis, things like that? Other differences in the various laws. Think about if you're a financial institution, some of the laws treat data that is subject to the Gramm-Leach-Bliley law, which is the first, which is the national financial data privacy law. Some of the states treat just the data as exempt from the state law. Some of the states treat the entire entity as that is handling that financial data as exempt from the state law. Same thing with healthcare law or healthcare data. If you're subject to HIPAA because you're a covered entity, you might have an entity-wide exception. If you're a business associate to a covered entity, you might have just a data. The exception might be scoped just to the data, or it might be scoped to the entire entity. It depends on what state you're in and what that specific law says. So what can you do now? I saw there was another question. We'll get to it in a second. First, you need to get your arms around the data flow. You need to understand where you're getting personal information, what personal information the company has, why it has that information, what are you doing with it, what is the purpose for which you've collected it, who you're sharing that information with, and how you're deleting it, if you're deleting it. So those are important questions to get around that kind of data inventory, data mapping, data flow mapping, really, really helpful as you start to think about some of the next steps in terms of what kind of documentation you need to demonstrate compliance. Inventory your third-party relationships. For companies that have been dealing with CCPA, for companies that have been dealing with GDPR, many of those companies probably have already started doing this work because of the requirements in those laws. If you haven't, you'd be either because you aren't those laws don't apply to you, or you just haven't had a chance to get around to it. Well, now you have more jurisdictions that are going to require very specific provisions or very specific requirements in your contracts with any third parties that you're sharing data with, especially vendors or vendors or processors, depending on how you define them and what state you're in. It's going to be an important thing to think about how you deal with the contractors or service providers that you have today, how you set up a master services agreement or something along those lines moving forward to make sure that you have the proper language in place. Those sorts of issues are important to deal with. Reviewing and updating your public-facing privacy policies. Nick mentioned the magic words. California has some very specific magic words like the do not sell language that we mentioned earlier, but other states have their magic words as well. And you're going to have to look at your privacy policy and decide, do you need to make any changes to that privacy policy, and how those, and if you do, how you're going to go about implementing those changes. We're starting to see clients that implement these changes by simply sort of making their privacy policy longer. And instead of the 8-page privacy policy, now it's a 12-page privacy policy because you have a Virginia section and you have a California section and you have a Utah. We've started to see some clients that sort of have rearranged the privacy concept pretty comprehensively and have like an online privacy center, and then they have specific state by state privacy notices that are shorter and much more targeted to folks in that state. So you'll have like a web page that says we care about your privacy, and then you have a link to the California privacy section or privacy policy, and it has a very specific set of requirements about what we do with folks with data from folks in California. So different ways of kind of cracking that nut, but you have to deal with it. Shoring up your back end, and that's really the flip side of the external privacy policy is how do you make sure you're documenting what folks are supposed to be doing with the data that you are collecting? What kind of policies and procedures do you have in place to deal with the consumer rights requests that Nick mentioned earlier? When folks do come and ask for access to the data that you have about them, ask for the ability to correct the data you have about them, et cetera. Those sorts of things, you're going to want to have a nicely documented process in place that you can show in case you ever get a complaint, that you can show you're following in terms of how you respond to folks who submit those requests. Train your employees. This is another sort of, how do you make sure that everybody knows what they're supposed to be doing and what they're not supposed to be doing? And that's training, and that's having nice policies that are easy to read, easy to access. Folks know where they're supposed to go when they have a question about, whether they can do certain things with data. Can they use data to sell more on Facebook? Can they use data to, come up with append their, your customer relationship management database and really make it nice and rich? What are you going to be doing with? How are you going to be doing that? Are you going to be buying data from a data broker, and what does that mean in terms of your privacy policy? All that kind of good stuff. You're going to want to have you're going to want employees to know at the very least who they're supposed to be talking to, what the guardrails are, what the questions that they need to ask to try to avoid getting into any sort of compliance trouble. And then, a little bit of a self-serving piece of advice: ask your lawyers if and when you need help. These are complicated things for the next few years as people sort of figure out what these mean from an operational perspective, as the regulators and policymakers start to figure out how they want to enforce these laws. There's going to be a lot of questions. There's going to be a lot of gray area, and we're here to help as much as we can. Oh, and last but not least, how are things going to get more complicated? Sorry. More states almost certainly going to be part of the alphabet soup. Washington, Minnesota, a few other states perennially come very close to adopting comprehensive privacy legislation. It seems very likely that at least some states will add to the list. At the very least, we are definitely seeing sort of what I think of as subject-specific privacy legislation. The most recent example of that is something that California just enacted last week, 2 weeks ago, the Age-Appropriate Design Code Act,
Yep.
which is ostensibly a privacy law designed to help protect kids online, but it actually ends up having pretty significant and broad impact across the internet, across apps and websites and things like that might reasonably be used by kids. And so there's things like that you need to kind of watch out for. And then finally, there's federal legislation, which is always on the agenda, never seems to get done. We'll see if that happens anytime soon. So I know we're over time. Thank you guys for listening.
Happy to take any questions you might have. I know we have a couple already submitted.
Yes, we did see quite a few come through, so we can jump in right there.
Yep.
So starting with Tim Wilson, he asks, are there any specific areas that matter where the different state level laws differ in their definitions of personal information?
Yeah. So a big one that jumps out right away is that California applies personal information not just to consumers but to households, and that's not something that you see with the other states. So with California, theoretically, just just an address, not necessarily connected to if we were all one big happy family here and we just had our address, but it didn't say Nick Chandler, Laura Gell, or Daniel Alvarez. Just that address itself could theoretically be personal data in California, where it isn't in the other states. And another key difference is in the exceptions. Each state has slightly different exceptions to what's not covered. So you can basically think of anything that's theoretically personal is covered broadly by all the states, but depending on the state, you might be able to get away with certain things in Virginia that you can't get away with in Colorado or Utah.
Yeah.
We also had a question come through from Chris. If the data subject is a resident of Virginia, but is temporarily located in Ohio when the data collection starts, are we required to determine if the data subject is a resident of Virginia? And how do we determine that origin of residence?
Yeah, so that kind of operational question, I mean, you don't have a requirement to go out and get more data about people to kind of figure out how to comply. But if this person, let's say it's a contractor and they sign their contract and they tell you that their address is, Richmond, Virginia, the safest thing to do is probably treat it as if it is subject to the Virginia law, and then kind of work backwards from there. Like, is there a reason why we can treat it as not Virginia?
And more broadly, you're going to have a question, over and over when you get these requests. Does this person really live in California? Does this person really live in Virginia? We don't know who they are. We've never heard of them. And what do we do? And so it's a question really of how many resources you want to devote to proving that they don't really have this right versus just complying with the request. And a lot of businesses have kind of thrown up their hands and said, okay, if anybody asks, we'll just give it to them because it's not worth our time to try to go down the rabbit hole of figuring out whether they're really in Ohio or in Virginia.
We also have a question coming from Drew. Is any/all of the legislation retroactive? Does data collected prior to CCPA have the same requirements for using and sharing?
So yes, sort of. So it's not retroactive in that it doesn't apply to what you were doing with the data necessarily before. But if you still have that data now, you're responsible for it under the new laws. So just because you collected it in 2019, if you're still holding on to it, if you're still using it for X purpose, or even just holding it, right? Because you might have it in the future, or nobody's asked you to delete it yet. Those restrictions apply to your current use of it. So the prior collection doesn't get you out of it, but if you were doing something with it in 2019 that was fine in 2019, but now requires something extra in 2020, that 2019 stuff is okay. But if you're doing that again in 2022, 2023, you may need to update your processes.
Another wrinkle there is in California, some of these rights apply to data that was collected in the 12 months prior to the request from the consumer. So if a data subject or consumer sends you a data access request that on January 1, it applies to data that you collected the prior 12 months, which means that you will have needed to go back to before the day that the thing became effective to find data that you collected about those people. So this is one of those, Laura talked about how, I forget the word you used, wacky.
Probably.
Yeah.
Use that a lot with these laws.
Yeah. This is one of those like weird quirks of the law that I don't think they quite appreciated when they wrote it. But that's the way it works. You're supposed to go back the 12 months.
Well, and even in your privacy policy, you disclose the categories of information collected about individuals in the preceding 12 months. So basically there is a look back period where you have to, even if the law takes effect now, you need to be looking back, from January of 2023, what did you do in the preceding 12 months? So that's where it comes into the sort of old data category.
Yep.
Matt asks, are the definitions of share classified now, and will do, I'm having a hard time reading this one. Will the share actually be delayed? Okay.
I think maybe the question's going to the fact that some of these definitions and regulations implementing these laws have yet to be actually published. That's another, I think we'll go with wacky again, aspect of trying to comply with these laws. If the regulators don't tell you the details of how they're interpreting them and put it in regulations, right now it's the end of September and we're guessing, but we have to be in compliance January 1st. So it's going to be an interesting couple months. In a number of states, I know Colorado is still working on theirs, California is still working on theirs, and we don't know. I think the question is, will do not share be delayed enforcement? I seriously doubt it. California does not seem to be in a mood to delay enforcement, at least in part because they're trying to prove that there shouldn't be a federal privacy law because they see themselves as the toughest privacy enforcers in the country. So they're in a mood to sort of speed up enforcement or to look tough. So I think that they will probably take the view that sharing means what sharing seems to mean, which is if you give access to that data to anyone other than within your company, you're sharing it.
Yeah.
Thank you for that. And then one last question before we stop the session. Ali asks, my understanding is that nonprofits are exempt from CCPA. Do you know if and how these other state regulations apply to nonprofits?
Yeah, this goes to the differences. So I think California only applies to for-profit businesses. I feel like Connecticut or Virginia is one that applies to all organizations, sort of corporate organizations in the state, or that collect the data from the state. So there's not a nonprofit. Is it both, or is it? I can't remember.
I can't remember if it's both. So Virginia applies to any organization in the state. There are a couple of weird exceptions for like state educational institutions are explicitly exempt. But if you're in Virginia and you're, say, the Nature Conservancy with a huge mailing list all around the world, you have to comply with Virginia's law. And some of the other states have similarly kind of like weird carve outs where educational institutions, certain nonprofits are carved out, but again, it's kind of a weird state by state thing. But I mean, generally, yes, they're kind of carved out, and there are some weird arguments because a lot of the applicability is that you're doing business in the state, and if you're a nonprofit, you could maybe argue that you're not doing business. but safer just to look at what the exact exemptions are.
Well, it looks like that's all the time that we have for questions. I just want to thank you so much for joining us today at the SDEC, and thank you so much for sharing your expertise on this very important subject and discussion. I think your perspective is very unique, and it really brings a lot to the table. So thank you so much for spending your time with us today.
Thanks for having us.
Thanks for having us. And if there are any more questions, our contact info is on the slide. We're happy to discuss.
Perfect.
Excellent.
Thanks. Bye, everybody.
Thank you, guys.